Hey everyone, I'm Attractive Nuisance, and I'm here to talk about the law, particularly in the US, but also in Canada, and kind of compare and contrast. Today we're going to be talking about fundamental rights on the 14th Amendment. If you like this kind of content, you can follow me on Leisurely Law. It's my YouTube channel, and you can follow me on Attractive Nuisance on Twitch. So if you want to like and subscribe, that would be fantastic, and we can get more of this content out. Thanks for joining me, and we'll just dive right in. As I said, today's conversation is about fundamental rights and the 14th Amendment. Why? The primary reason that I chose this topic is A, I'm very passionate about fundamental rights and very passionate about the Constitution and how that protects fundamental rights. B is that we're in 2025, we're looking at Trump's inauguration, January 20th is impending, and there are some really important things that we're looking at that will be changing and potentially impacting the Constitution in the US. So I want to emphasize those changes and how that will evolve. Let's get started with Trump's abortion policy. This is supposed to be an apolitical discussion. I'm really focused on the law as it stands currently and how it will change and how the Constitution will evolve in the US. So I know abortion is a really hot button topic, and I'm aware that it can be very political, but in this context, this is not a political discussion. This is a legal constitutional discussion. Trump has proposed to do a number of things with abortion through the years. So in 2016, he was definitely more anti-abortion. He's changed a lot. He's kind of morphed his views. He says a lot of things, and we don't really know where he stands on abortion. So it's been this really interesting conversation in the US, especially following certain cases that have come out. What Trump's recently saying, along with, we've got J.D. Vance and Elon Musk in the background there, Trump has mentioned a national ban and how he will not support a national ban. He has actually, in fact, said that if it crosses his desk, he will veto a national ban on abortion. This came out prior to the election and was kind of this grab on women votes. He was trying to come across as pro-choice without conceding his pro-life perspectives and political followers. And so it was this kind of dancing the line, trying to get extra voters and really win that women's vote. But what's really interesting is while he would veto a national ban, he's saying that that would give all the power to state control and state legislation, which might sound okay. On its face, it does sound very pro-choice. It sounds very pro-women, and Democrats might be more likely to vote for him. That might be something that sounds attractive. And today I really want to unveil why this actually is more problematic than it sounds. Trump's policy of no national ban but leaving it to state control, that deals with jurisdictional issues, state supremacy. So we have that federal versus state control and jurisdiction. It is often controversial and very highly debated who should have jurisdiction and who does not. So does the federal government have the jurisdiction to make the laws in a particular area, or should the states be legislating with their state police power? That is really the crux of so many issues in the US, and it's not as simple as it looks. I want to really emphasize that the veto of a national ban would not necessarily solve every problem. Okay, so I want to talk to you about fundamental rights today because they are your fundamental rights, they are my fundamental rights, they impact everyone, and this will change the environment of the Constitution in the US and ultimately change the trajectory of individual rights. And I know that a lot of people, I would say even most people, are really passionate about individual rights. We saw that especially during COVID. People are saying my rights, my individual rights, freedom of speech, all these things. These are impacted by the Constitution. These are impacted by Trump's policies that he could be inputting in 2025. It could have drastic changes, and we could see crazy things in 2025. Kind of scary. To really get into the context of these policies, we do need to understand the history of abortion in the US. Not a great fun topic. I don't really want to be discussing this, but it is the most obvious way to discuss fundamental rights right now. I am not proposing either stance, but I want it to be understood how this is affected by the Constitution and also how it affects the Constitution moving forward. I'm sure many are aware of Roe v. Wade. Roe v. Wade was a very known case name, kind of the abortion case in the US up until more recently. It was this case where there was a state statute that made abortion illegal except to save the mother's life. It was a very, very restrictive legislation for abortion. And that ended up in the Supreme Court. At the Supreme Court level, the court agreed and said that the legislation at issue was quite restrictive and extreme and infringed on constitutional rights. There was a protected right to abortion as a fundamental right. And that's wild. That is so strong. Fundamental right is the most important right in the US. It's the strongest, most supported. The court did add that it was not an absolute right. There can be exceptions for a compelling reason, necessary reason, etc. So Roe set the stage for abortion in the US, and that's been highly controversial for a long time. In Planned Parenthood v. Casey, the court re-examined the issue of abortion as a fundamental right, and it actually affirmed Roe v. Wade, and it added all these other nuanced views to Roe v. Wade. It didn't just reiterate the same things. It really emphasized that personal liberty is protected, and that's different from just abortion as a right. It's personal liberty. And this is kind of where we see the evolution of privacy as a fundamental right. We have this personal liberty that's now protected by Casey, and Casey added an additional safeguard for specifically abortion legislation, that legislation can't cause an undue burden to women seeking an abortion. Because what was happening is states weren't exactly outlawing abortion, but they were imposing all these so-called safeguards to obstruct women from getting an abortion. So it was in effect really barring abortions. And so the court outlined this test for an undue burden, that it was the purpose or effect of placing a substantial obstacle in the path of women seeking an abortion before viability that was essentially unconstitutional, that kind of undue burden infringed on the constitutional right to an abortion. And it was really building on Roe. We have these building blocks protecting individual rights, which is a beautiful thing. We've got now protection of privacy, protection of personal liberty. These are things that are all really, really important to all of us. Obviously, the abortion context makes it more convoluted and difficult, but from the perspective of individual rights, I myself appreciate that view. Casey also outlined this discussion of stare decisis, which is essentially precedent, and I will get to that in a moment, because what we see really changed the tides of the Constitution and of fundamental rights in the US, because Dobbs v. Jackson Women's Health Organization came out recently, and it overturned Roe v. Wade. And in essence, it also overturned Casey as well. So two highly precedential, seminal cases for fundamental rights and abortion were overturned by the Supreme Court. The court found that the right to abortion was no longer a fundamental right. And it wasn't just the right to abortion. The court actually found that the right to privacy, the umbrella term that abortion fell under, was no longer a fundamental right. What does that really mean? There was a lot of news coverage on this, a lot of media talking about this issue, and I know that there were lots of different perspectives. Some people said that it was a privacy rights issue. Some people said that it was a women's rights issue. Some people said it was a federalism issue of whether state power is given or whether the federal government overcomes the state power. And all of those perspectives are correct. That is what was happening in Dobbs, because we see privacy rights impugned by this because the court found that there were no privacy rights, or rather that privacy rights are not fundamental under the US Constitution. So obviously privacy rights are implicated by this decision. We also have this federalism issue because it is what level of deference are we providing to states? Because that is kind of the essence of federalism, is this balance between federal and state power. So if we have fundamental rights as more protected, it does change the state-federal power balance. It was about abortion rights, and that impacts women. So it was really all these issues into one cesspool of confusion that arose out of Dobbs. I think that's what made it such a convoluted issue, because we weren't able to see that it involved fundamental individual rights and freedoms. Because if that's what we boiled it down to, and I think a lot of us can agree on individual rights, when we put it into these more biased or left or right leaning conversations, it really veils and obstructs the true meaning of these decisions. This was not an unexpected decision, unfortunately, because Trump nominated 3 Supreme Court justices into the Supreme Court. And he did so intentionally. He has actually expressly said that he did so because he wanted Roe v. Wade to be overturned. He nominated Supreme Court justices who would overturn Roe v. Wade. The court was stacked against the abortion right and the right to privacy. We weren't surprised when this happened. And this was the beginning of Trump's pattern of behavior that has led to the erosion of the Constitution. And that is the essence of what I'm talking about today. This is fundamental rights. This is fundamental freedoms in the US, and how we are being denied them, and it's being eroded from the Constitution. We no longer have this right to privacy. The states are given more deference, and abortion is no longer a protected right. Those are the things that Dobbs decided. And those were the conclusions that the court came to. So we get this hodgepodge of impacts that we are distracted from because it became such a controversial issue. Now, stare decisis is the idea of precedent. It's the idea that in British common law and then in the US legal system, we follow precedent of previous courts at a higher level. So Supreme Court is the highest court in the country, and so other courts have to follow the precedent or the seminal cases that are decided by the Supreme Court. Stare decisis is a very important principle to the US because it kind of makes up the legal system. Without stare decisis, every court can just make up their own arbitrary decision based on redundant information. And it also makes it a lot harder for justices because they have nothing to rely on then. But the stare decisis is this idea of consistency that the law should be providing. Why Dobbs really was so important to this stare decisis idea is that it really took away from stare decisis. Dobbs, by overturning Casey, made this massive change to how we view stare decisis in the US, because Casey outlined that stare decisis must be upheld, ultimately, and that there are 4 instances where we can move away from stare decisis when we would overturn a specific finding of law. Casey outlined these 4 principles, and those are specifically that if a previous law precedent is unworkable, that it no longer works in today's society, we have evolved to a point where we cannot apply this, then the case should be overturned. Similarly, if the case can be removed without serious inequity to those who have relied on it, or without causing significant damage to the stability of society, so essentially no one will notice if we change this, then the case can be overturned. Doctrinal anachronism is when it is no longer valuable to society. So yes, we have this law, we have this kind of idea, but we haven't followed it for like 100 years. For example, in Canada, the death penalty, I know I'm throwing out another hot button topic. In Canada, we had the death penalty until, I don't know, maybe the 80s, 90s, but it really hadn't been used for like 80 years. So it was really no longer relevant to our society. And so it kind of just fades away into oblivion and nobody really cares about it anymore. And that is the idea of doctrinal anachronism. The fourth and final topic that Casey outlined was that the case is premised on a fact that changed to render the central holding irrelevant or unjustifiable. So if the court has made this holding in this precedential case, and it's no longer relevant to society or it's unjustifiable. So we see this in things like Plessy v. Ferguson, which is the case of separate but equal, which we know now is unconstitutional and also discriminatory, racist, and there are a lot of things wrong with it. The court eventually recognized that and overturned Plessy v. Ferguson because it was no longer justifiable under the Constitution. So we recognize the evolution of society, and that's what these all come down to. So Casey outlined this structure for following stare decisis and when we can diverge from stare decisis. Fast forward to Dobbs. Dobbs overturned Roe v. Wade and Casey in finding that privacy rights are not a fundamental right. And by doing so, it really ignored this stare decisis conversation in Casey. It overturned it, it overruled it, and it completely ignored it because it didn't follow that outline of what justification do we have for deferring from this precedent. Why can the court do this? And the Supreme Court decision of Dobbs outlined why they were overturning Roe and Casey, and there was essentially no justification for overturning stare decisis. And that is hugely problematic to our legal system because not only is it unconstitutional, but it also doesn't follow our legal history in the US. It doesn't follow British common law. It doesn't follow anything we've ever done with following precedent. And without having precedent and stare decisis, our entire legal system falls apart. So Dobbs did far more than impact abortion and women's rights. And those aren't small things by themselves, but privacy rights, abortion rights, and the legal system entirely as a whole are really, really big. And I think the court kind of glossed over that and refrained from showing people how important this conversation was and how important stare decisis is to the US. Moving forward, the 14th Amendment and due process are really what we're talking about today. The 14th Amendment, specifically the Due Process Clause, looks after the life, liberty, and property. So it's that the government can't deprive anyone of life, liberty, or property without due process of law, commonly and colloquially called the Due Process Clause. Really important to the US because this is what protects people's individual rights. This is what provides them essentially a remedy in court. It gives them a way to be like, hey, no, look, it's unconstitutional. There must be a remedy for me. And so it's implicated when there is a deprivation of a legal right. Now, there's a lot to unpack there. If you're in law school, that would take like 3 classes to unpack that sentence, because a deprivation can be a certain thing, what a government is a certain thing, what an individual is, and then a legal right. What is a legal right? Usually it means that you're legally entitled to something, but it can mean different things. And just to make it more complicated, due process has 2 different prongs. We have substantive due process and we have procedural due process. It gets a little confusing and a little complicated, but I'm going to try to focus really here on substantive due process and legal rights, looking at more fundamental rights. Once we get to that point where we see that a legal right is impacted, then the analysis really becomes, is it a fundamental or is it an economic or non-fundamental right? Because a lot of decisions will hinge on that, and it seems really arbitrary and semantic, but it's crazy how much we rely on that analysis. Fundamental rights have been a very convoluted source of conversation in the US. We really see fundamental rights are obviously the enumerated rights. They are explicitly mentioned in the Constitution, things like you have the freedom of speech. That's pretty clear, so we know that speech is important in the Constitution. We have these implied rights, though, that muddy the waters and make it way more difficult to tell if it's a right or not. That's what I'm coming up to with Dobbs. So an implied right previously was a right that is fundamental to ordered liberty, or it's deeply rooted in the nation's history and tradition. That is so vague. And you can see this if you read the case law leading up to this. It gets really, really weird really fast. And interpreting what this means is like reading a text from your mom, and you can tell she wrote it with good intentions, but somewhere along the way you're left asking, wait, what does this actually mean? What is she saying? What's happening? And that's really the court interpretation of these phrases. We had kind of reached a good place, though, and the courts were kind of understanding what that meant. We had a lot of tests to determine if it was an implied right, and there was kind of this balance that was reached by the court. And then Dobbs busted in and changed everything, because Dobbs' opinion said that an implied right must be both deeply rooted and fundamental to ordered liberty. And this adds a whole new hurdle to making something an implied right. And essentially, with that one phrase, wipes out an entire world of rights, because so many rights are implied. It's not explicitly mentioned in the Constitution, because the Constitution cannot feasibly cover every right. It would be hundreds of thousands of pages long if we wanted to cover every possible scenario. And so the Constitution was kind of vague with that. But because Trump nominated those 3 justices, the tides really changed. And now there's this deeper test that's harder to pass for implied rights. And so you can see why enumerated rights would be more protected and easier to find. But these implied rights are now going to be so difficult to protect, because proving that you have a right can be so difficult. And if you can't even prove that, then you can't prove a deprivation of said right. So that really impacts what people can take to court and what remedies are available. Aside from that, which is already so complex, we also get this strict scrutiny versus rational basis review. This is more imperative when it comes down to legislation and when the court is reviewing legislation for unconstitutionality, because it determines the standard of review that the court looks at state legislation with. So are they reviewing Florida's state legislation with strict scrutiny, or are they reviewing it with rational basis review? Why does this matter? This is so semantic, but it actually changes everything. So under strict scrutiny, the court, the Supreme Court or another federal court, will look at state legislation with strict scrutiny to see if it is necessary to achieve a compelling government purpose. This means that the state has to really show why they need this legislation. Otherwise, it'll get overturned as unconstitutional. So this is a much stricter scrutiny of the legislation, and it kind of, as some would argue, imposes on state supremacy, because it reduces state police power and gives the federal government more ability to scrutinize legislation and find it to be unconstitutional. Versus rational basis review. Rational basis review gives a standard of it needs to be rationally related to achieving a legitimate government purpose. This is the easiest standard to follow, because there is a presumption first that the legislation is constitutional. That means the Supreme Court is reviewing this legislation with the assumption that the legislation is constitutional, which leaves it up to the person who brought it to court in the first place to prove why it would be unconstitutional, which means they have to prove that it's not rationally related to achieving a legitimate government purpose. legitimate government purpose, they can make something up when it gets to court. So even if they made abortion legislation to obstruct women from obtaining an abortion, by the time it gets to the Supreme Court, the government can argue that it's to protect women's rights or it's to protect family life. And these are legitimate government purposes to the court. And if they can show that it's rationally related, which is a very loose standard because most things can be rationally related in some way or another, then it's all good. And that legislation is constitutional. And so I think you can see here how strict scrutiny versus rational basis review make a huge difference. Strict scrutiny, it is more likely or it's more possible to find that legislation is unconstitutional, while rational basis review is essentially lip service to the law. And that's my humble opinion because I am passionate about this and because I think rational basis review has so many holes in it. That has been my experience with rational basis review in reading the case law. Strict scrutiny and rational basis review are coming into this conversation because of how it relates to these enumerated versus implied rights. So fundamental rights versus non-fundamental rights, which are more often economic rights, something like that. Fundamental rights, when they are implicated, they are given strict scrutiny. So for example, if abortion is considered to be a fundamental right, then any legislation impacting abortion would be viewed by the court with strict scrutiny, which means it is more likely to be found unconstitutional if it restricts a woman's right to abortion. Versus rational basis review, which is not a fundamental right, then it's viewed with this rational basis review. So following Dobbs, abortion is no longer a protected fundamental right, and so any legislation that impacts abortion is analyzed by the Supreme Court under this rational basis review. That means that states can find any legitimate purpose that's rationally related to achieving that purpose, then it's fine. It is presumptively constitutional. This gives states a lot of power. And so this wasn't just a state-federal power question. No, it's how much accountability are we going to have over the states? And the court in Dobbs said pretty much nothing, because any case or any legislation that goes to the court is going to be found presumptively constitutional. And that is a really, really hard standard to disprove. I really just don't want to be the bad news bearer all the time. I feel like I'm going to earn that title Gandalf has of like Stormbringer, because I don't have a lot of positive things to say about 2025 and its effects on the Constitution. I've recently been playing a lot of Baldur's Gate 3, and I've been really seeing in a very visceral way the effects that decisions have on later interactions. So if you've played Baldur's Gate 3, you know exactly what I'm talking about. You know, you pickpocket someone just because you want that extra cash. You know, you want something specifically from them. They get a little upset. That impacts their attitude to you. They don't really like you. And all of a sudden you're fighting them. And then the whole village is fighting you. And it's this whole massive thing that usually causes a reload. We're looking at this parade of horribles resulting from Dobbs. And this is a law school term that we use. It basically just means a cascading effect that is not good. We are looking at things that aren't going to be great, and it's a downward trajectory that isn't good for the law. That's what this parade of horribles is. So if we have these negative consequences resulting from Dobbs, that's what we're looking at, and I think I've really outlined that. If it's not a fundamental right, then it's rational basis review, which gives states a lot of power to step on people's rights. And not only that, but it erodes the Constitution itself, because this isn't just about abortion. This is about individual liberties, and this is about fundamental rights. What is a fundamental right? What level of rights are we going to protect? And the court has found not privacy. And what does that mean? Privacy rights include things like things that happen in your home, your personal privacy at home. And the common example of that is pornography or family planning, things like that, that are intimate decisions that you make in your home that could be invaded by the government. These are no longer being protected. They're not fundamental rights. So feasibly, if a state passed legislation saying that they were going to, I don't know, this is extreme, but put cameras in your home to watch what you're doing, or to track your computer searches, or to have search and seizure warrants for any books they don't like in your home, they could do that. Because if they can find a rational basis for that, then the court will uphold that legislation. And that is terrifying. So this isn't just about abortion. Whatever stance you take on abortion doesn't matter, because this is about individual rights that will affect you, regardless of your stance on abortion. But we do see this erosion of constitutional protections resulting from the Dobbs decision. And ultimately, that's the erosion of due process. So the 14th Amendment due process clause is weakened by this, because if it's not protecting the right to privacy and all the things that fall under it, then that's one less thing that substantive due process covers. And it was already pretty weak. If you're from Canada, you know that we have the Canadian Charter of Rights, and in that is Section 7, which is the right to life, liberty, and security of person. And that word changes everything, because in the US, the Due Process Clause protects life, liberty, and property. It's much more restrictive. Life, liberty, and security of the person is much broader, and that is where our abortion right comes from in Canada, is this security of the person and protecting physical and personal autonomy. With the Dobbs decision, the already weaker substantive due process is even more weakened. It has been eroded to a point that privacy is not a right. These fundamental rights are no longer protected by the government. And we don't know what's going to happen with that. Really, bringing it back to the main topic here is Trump's policies and how this will affect rights, because this is coming up really, really fast. This is January 20th. We are looking at it. We are looking at 2025 being a really historical monument to our legal system, and which way it's going to go, I don't know. And I really, really hope that it'll go towards individual rights, but I'm not optimistic that rights will be protected. With Trump, his policies are focused on this state control, which again, he made it sound like it was pro-women. He wanted to gain women's votes, but his idea is much more insidious. It's not just about supporting women. It was about giving states control, which actually gives a lot more power to governmental entities and erodes away the constitutional rights that are supposed to be protected. If states can make their own legislation and is viewed by rational basis, any legislation can go, essentially. There isn't any accountability or these oversight bodies to protect our fundamental rights. And the concern here is that this is a pattern of behavior. It wasn't a one-off decision for Trump to nominate the justices to the Supreme Court to overturn Roe. That was a very intentional, premeditated decision, which is concerning already. But the pattern of behavior shown by Trump has also demonstrated his disregard for individual rights. There are so many examples of how Trump's policies or his proposed policies have the effect of eroding away the Constitution, reducing your individual rights, and impacting personal freedoms. This is massive because the US Constitution is no longer going to be upheld. And what do we do with that? And what is 2025 going to look like? This is about your Constitution, US citizens. Your Constitution is at stake here. You are the ones who stand to lose because your rights will not be protected. And I threw in that it's the year of the snake, which is to show versatility and adaptability and flexibility with changing times. And I think that's so apt because this is going to be a crazy year of change. My fingers are really crossed for America and for Canada too, because we are right there as border neighbors. Let's make 2025 be better than it could be. Thanks for joining me. I'm Attractive Nuisance, and you can follow me on YouTube at Leisurely Law. Feel free to leave your thoughts and ideas. I'd love to hear them. I'd love to know what you're thinking. Thanks for joining me.